Welcome to Law Made Simple, your trusted companion for understanding complex legal topics in a clear and straightforward way. Today, we are focusing on one of the most common financial issues faced in India, cheque bounce and its legal consequences. Cheque dishonour is not just a civil wrong but also a criminal offence under Indian law. The governing law here is the Negotiable Instruments Act, 1881, specifically Section 138, which deals with the offence of dishonour of cheques. This provision was strengthened through amendments, most recently in 2025, to ensure faster trials and reduce the backlog of cheque bounce cases. A cheque bounce occurs when a cheque is presented for payment but is dishonoured by the bank. The most common reasons include insufficient funds in the account, mismatched signatures, or even closure of the account. Each of these situations can trigger serious legal consequences for the drawer of the cheque. For example, imagine a cheque of 50,000 Indian rupees issued to a supplier. If the cheque is dishonoured due to insufficient balance, the payee has the right to initiate legal proceedings under Section 138 of the Negotiable Instruments Act, 1881. This transforms what may seem like a simple financial lapse into a criminal matter. The law ensures accountability in financial transactions and protects the trust between parties. It discourages casual issuance of cheques without maintaining sufficient funds in the account. This is why awareness of these provisions is so important for individuals and businesses alike. At Law Made Simple, we believe that legal knowledge should be accessible to everyone. By understanding the provisions of the Negotiable Instruments Act, 1881, and its amendments, you can safeguard yourself from unnecessary legal troubles. So, stay tuned as we break down the penalties, jail terms, and offences available under this law. Don't forget to like, share, and subscribe to Law Made Simple for more legal insights. The legal framework for cheque bounce cases in India is primarily governed by the Negotiable Instruments Act, 1881, specifically Section 138, which criminalises the dishonour of cheques. This law ensures that cheques remain a reliable instrument of financial transactions. The 2025 amendment to the Act introduced faster trial processes to reduce the backlog of pending cases. When a cheque is dishonoured, the payee must issue a legal notice to the drawer within 30 days of receiving information from the bank. The drawer then has 15 days to make the payment. If the payment is not made within this period, the payee can file a complaint in court within 30 days after the notice period expires. Jurisdiction is another important aspect. The law clarifies that the complaint can be filed in the court where the cheque was presented, not necessarily where the drawer resides. This provision makes it easier for the payee to seek justice. For example, if a business cheque is dishonoured in Mumbai, the complaint can be filed in Mumbai itself, even if the drawer lives in Delhi. This ensures convenience and fairness for the aggrieved party. The framework is designed to protect the credibility of cheques and to instill confidence in financial dealings across India. By enforcing strict timelines and clear jurisdiction rules, the law strengthens accountability in commercial transactions. The penalties for cheque bounce under Section 138 of the Negotiable Instruments Act, 1881 are severe to discourage misuse. The law provides for a fine up to twice the amount of the cheque. In addition, the drawer can face imprisonment up to 2 years. Courts have the discretion to impose either fine, imprisonment, or both, depending on the seriousness of the case. The 2025 amendment further streamlined recovery processes, ensuring that rightful claimants receive justice more quickly. Another important provision is Section 139, which presumes that the cheque was issued for the discharge of a debt or liability. This shifts the burden of proof to the drawer, making it harder to escape liability. For example, if a cheque of 1 Indian rupee lakh is dishonoured, the court can impose a fine of up to 2 Indian rupees lakh, along with imprisonment, depending on the circumstances. This strict penalty structure discourages casual issuance of cheques without sufficient funds. The law is designed to protect the integrity of financial transactions and to ensure that cheques remain a trustworthy instrument in India's economy. While the law is strict, there are certain defences available to the drawer under the Negotiable Instruments Act, 1881. A common defense is that the cheque was not issued for the discharge of a legally enforceable debt or liability. However, Section 140 makes it clear that insufficient funds cannot be used as a defense. Similarly, Section 141 extends liability to company directors and officers if a company's cheque is dishonored. This ensures that individuals behind corporate decisions are held accountable. For example, if a company issues a cheque that is dishonored, the directors can also be prosecuted, not just the company itself. This provision prevents misuse of corporate structures to escape liability. Technical errors, such as signature mismatch or presenting a post-dated cheque prematurely, may be considered differently by courts. Genuine mistakes are distinguished from fraudulent intent, ensuring fairness in the application of the law. The 2025 amendment streamlined defense submission timelines, making the process more efficient and reducing unnecessary delays. To conclude, cheque bounce is a serious offence under the Negotiable Instruments Act, 1881, specifically Section 138, as amended in 2025. The law provides for penalties including fines up to double the cheque amount and imprisonment up to 2 years. These provisions protect trust in India's financial system and ensure accountability in transactions. For example, a dishonored cheque can lead not only to financial liability but also to criminal prosecution, making it essential for individuals and businesses to be cautious. Awareness of these laws helps avoid unnecessary legal trouble and promotes responsible financial practices. By understanding the framework, penalties, and available defences, you can safeguard yourself and your business. At Law Made Simple, our mission is to make legal knowledge accessible and practical for everyone. We hope this video has helped you understand cheque bounce penalties and jail terms in India for 2026. Don't forget to like, share, and subscribe to Law Made Simple for more legal insights and updates.